Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. Har Har Mahadev, Jai Shiv Shambhu. Today we will discuss the chance to get bail under PC8. As we know that to get the bail under PC8 is not a joke. It is very much difficult because in a regular criminal case, we could get the bail easily, but it is not easier to get the bail in PC8 cases. Because regarding corruption, Honorable Supreme Court, even the Indian courts are of view that basically it is a social evil. And apart from that, the bail is not to be given in such cases. So basically, we have to work out on certain parameters. Usually, in these matters, the bail are not given as matter of routine. But basically, we have to see certain parameters by the virtue of which we could easily argue our case for the bail. So basically, we have to understand the defense strategy regarding the same. First of all, we will discuss about the anticipatory bail. Anticipatory bail means the bail before the arrest. Now, the important question arises how to move for the anticipatory bail as far as offences under PCAT is concerned. As far as anticipatory bail is concerned, there is no specific provision regarding the same in PC8. So basically, we have to rely on BNSS. Previously, we were having section 438 of CrPC. Now we are having section 482 of BNSS. So basically, as far as the corruption cases are concerned, the anticipatory bail would lie. So basically, regarding the anticipatory bail, you have to show that the entire allegations in the FIR are false. It is politically motivated, and apart from that, there is no prima facie case against the accused. If you are succeeded to sustain the same in that scenario, the chance to get the bail will be on the dominant side. But when the concerned prosecution argue that you are not cooperating, the custodial interrogation is required. In that scenario, you might be in the hot water. So to rule out all the scenarios, I request all of you to give the proper reply to the FIR. Because by giving the proper reply, you could inter alia show to the concerned court that the case is totally false, it is totally fictitious, and inter alia you are erred in the present case due to certain ulterior motive on the part of complainant. And if we are succeeded to show that the case is false, it is totally fictitious, in that scenario, the chance to get the anticipatory bail will be on the higher side. Because as far as anticipatory bail is concerned, simple formula is that the case is false, and in that case, by showing the anxiety, the concerned IO is willing to arrest us just to humiliate our image and reputation. So basically, we have to satisfy the criteria that the case is false. So basically, by giving the proper reply to the FIR, we could sustain the honorable court that even to the IO we have submitted everything, but he is willing to arrest without any basis. So in that scenario, the chance to get the anticipatory bail will be on the dominant side. Now I am coming on the regular bail. It is usually moved after the arrest as per section 483 of BNSS. Apart from that, there are certain points by the virtue of which we could easily get the regular bail in cases under Prevention of Corruption Act. Number one, the charge sheet is the milestone. Please be noted. The strongest point to get the bail is filing of charge sheet. If charge sheet is filed, usually the accused is inclined on the bail. And apart from that, the completion of investigation, no recovery is pending, the accused is in confinement since a long time are also important factor. In addition to this, if the accused is not having the criminal antecedent, there is no chance to flee away from courts of justice. And apart from that, he is cooperating. And inter alia, there is no chance to tamper with the evidences or to cause disappearance of the evidences. In that scenario, the chance to get the bail will be on dominant side. So basically, we have to chalk out the violation of section 35 subclause 1 subclause B of BNSS. Simply we have to specify that the arrest is illegal and it is done in violation of guidelines of Honorable Supreme Court, which is propounded in multiple cases. Apart from that, we are having the right to get default bail. Means if the charge sheet is not filed within time, in that scenario, by the virtue of section 187 of BNSS, we could easily get the bail. So basically, if the bail is default bail, the chance to get the bail will be 100%, not 99%. But in case of regular bail, in case of anticipatory bail, we are totally dependent upon discretion of the concerned court. So this point is very much important, please be noted. And apart from that, while arguing the bail application, we have to specify to the honorable court in which manner the case is false and why we are implicated. Simply we have to accord the plausible explanation to the allegations. And in addition to this, if the mandatory provisions are not complied with and it is applicable to your case, the chance to get the bail will be on the dominant side. For example, if there is no compliance of section 17A of PCA. In addition to this, if there is no compliance of section 35 subclause 3 of BNSS, the chance to get the bail will be on the higher side. So basically, we may conclude that if the accused is caught red-handed, more specifically in the state of Rajasthan, state of Uttarakhand, state of Haryana, the chance to get the bail immediately will be on the lower side. You have to wait till filing of charge sheet. Apart from that, as far as the DA case is concerned, the chance to get the bail will be on moderate side, because usually they collect the evidences and after that they file the charge sheet, and subsequently it depends upon the discretion of the court whether to incline the bail to the concerned accused or not. So basically, during the course of investigation, the accused is not arrested. Regarding this, we could get the additional benefit, but after filing of charge sheet, it is whole discretion of the court to incline or to decline the consent bail plea. And apart from that, if charge sheet is filed, the chance to get the bail will be on dominant side, and if you are having the medical issues, the chance to get the bail will be on the dominant side. So basically, we could say that the rule is of bail, not of jail, and the rule is applicable to corruption cases, but the court is of view that it acts like a cancer, and apart from that it is going to affect the economy of our country. Then usual pattern is that the court may reject the bail plea. So whenever you are going to move bail, more specifically in the cases involving the economic offences, for example, if you are charged with section 13 subclause 1 subclause A of PC Act or section 13 subclause 1 subclause B of PC Act, in that scenario you are supposed to give the plausible explanation of entire allegation in the FIR. If you are not giving the explanation and simply you are moving the bail plea, you could not be succeeded. So I think that I have specified you the material points which are required to be considered while moving for the bail plea. See you in the next video. Till then, Jai Hind, Jai Bharat.